Thing. Okay, thank you. Ellen, please take it away.
Thank you. If I could ask first for Russ and Stacy to please rename yourself, adding the city or area that you service, that would be great. And I'm very excited today. We have Stephanie Schneider. Stephanie has been practicing elder law for 30 years. She's board certified in elder law nationally and by the Florida Bar. She's the former chair of the Florida Bar Elder Law Section, and her practice includes estate planning, guardianship for minors and incapacitated adults, probate of decedents' estates, trust administration, special needs planning for people with a disability, and long-term care planning, Medicaid, VA benefits, Social Security benefits, etc. So I think in reviewing all of that, we may need to bring Stephanie back because there's no way in 10 minutes, 10 to 15 minutes, we're going to be able to cover everything that she does. But I'm really excited to have Stephanie here. And if everyone, any questions you have, if you can just write them down, then we're going to be having a question and answer time after the discussion with Stephanie. So please write them down and hold your questions for now. Stephanie, I have to get back to the other page. Here we go. Sorry. Okay, can you give us, well, first of all, I want to thank you so much for being here today. You really jumped in and provided so much good information, and I feel like we could do 10 of these shows and not begin to exhaust all of the things that you could teach us. I gave a very little overview of what you did, but what you do, but if you could give us an overview of yourself and the types of services that you offer to clients.
Thank you. So I know we have a lot of people with us today that are from Florida, but everybody can answer this question. Has anybody found the Fountain of Youth that Ponce de Leon supposedly found? No? Everybody's smiling. Okay, so that means we're all getting older every day, right? So what elder law is about is not working with clients over 60 years of age. It's really working with every consumer of any age because aging challenges happen. Especially we saw them at the beginning of COVID. Remember, we saw a lot of young, who we thought healthy people end up in the hospital. A lot of those people didn't have documents that named people they trusted to make medical and financial decisions for them. So aging challenges happen at any age, at any time in life, including a young couple who perhaps have their first child, and that child is born with special needs or a developmental disability. So my role is to educate people as to what they can do to help them get through those challenging times. Tell them what their options are so they can make the best informed decision for themselves and for their family.
Thank you, Stephanie. In guardianship, sometimes we think of guardianship as somebody who is perhaps very old or has been in an accident, but I know guardianship extends way beyond that. So in terms of when thinking about people to refer to you, I know we've spoken about special needs and everything. What are some things in guardianship that we may not be thinking about that would be important for us to advocate for our clients and make those introductions?
Okay. Is everybody, first of all, familiar with the word guardianship? I know we have some individuals that are from the Northeast states, and in some states they tend to call it conservatorship. So it really is a very similar process, although conservatorship mostly means to become guardian over the assets, whereas guardianship can be guardian over the assets and over the person in order to make medical or residential decisions. So I would say that as realtors, when you first meet the homeowner, you're going to get a sense of, based on how they're answering your questions, based on how they're acting, reading their body language, you're going to get a sense of picking up on maybe something isn't quite right. Maybe they seem to have their social skills intact, but when you start asking more detailed questions about the house, you're finding that they're not quite able to answer them, or maybe they turn and they look at an adult child for the child to answer you. If you're seeing some of those things, that could be a red flag that perhaps the homeowner has some sort of cognitive issue going on. The question is, do they have enough understanding and awareness to be able to work with you, to be able to sign the listing agreement, to be able to evaluate an offer when it comes in? If you have a doubt, you probably want to have a conversation and ask, is there anybody that they've given a durable power of attorney to? And if they say yes, you want to get a copy of that, look at it, or perhaps have an attorney that you work with in your closings review it to see if the document gives authority to enter into the real estate contract, to do negotiations. If it does, great, you are home free. Then you want to make sure that the listing agreement and the contract reflect the name of the person who is named as the financial decision maker, because they would be signing on behalf of the homeowner. But if you're told, no, there's no durable power of attorney, then the question is it too late? Is the person no longer sufficiently aware to sign a power of attorney? And that's where I think Ellen is, implying that we then might need to go to court, we meaning a family member, and seek to be appointed the guardian so they can go through with the real estate transaction. Now, if a guardianship hasn't yet begun and it's not an emergency, you're looking at somewhere between 4 to 6 weeks to get a guardian appointed. And then that guardian has to ask the judge for permission to be able to sell the home. So you're going to need 2 court orders. You're going to need the first court order, which is appointing the guardian, and then a second court order giving the authority to sell the property. And you're going to want to have that in your file as part of the real estate transaction. Now, in Florida, we do have an emergency process, and we're only allowed to use this if either we can prove to our judges that there's financial exploitation taking place, which seems to happen every week of this year from what I'm seeing, or the person is in imminent danger to their safety and well-being. So if you have a situation, I just consulted with somebody this morning whose sister had 4 people she doesn't know move into her home, and Adult Protective Services is trying to get them to leave. If that's the situation, we might be able to do an emergency guardianship, and then it's best don't ask the homeowner to sign the listing agreement because likely they don't have the necessary capacity. And you don't want anybody questioning your listing agreement down the road.
All very good points, and very disconcerting to think that you could have, 4 people moving in with a loved one that it doesn't have the capacity to give consent. I know you and I had spoken about children, adult children, children that are almost at adult stage that have different disabilities, and be surprised their parents when they realize that they don't have the ability to sign for them or to get medical information. And so when we're working with our clients and they share with us that perhaps they have a child with a disability, what would be, how would we make that introduction to somebody like you, and what would that look like?
Okay. Before I answer the question, I know, Dawn, you shared how happy you were that your sons came home for the holiday and then went back to school. Anybody else a parent? Yes. Minors over 18, combination of both? Yeah. Okay. Barb's going up, up, up. How many of you think that even when your children reach, well, depending on what state you're in, it could be 18 if it's Florida, might be 21 in another place. How many of you think that you're still going to be able to make financial and medical decisions for your children when they become legal adults? Anybody believe that? Well, then my job's done, because usually everybody's shaking their head. Yes, of course I can. You know, they're on my payroll. I'm paying for the apartment, or I'm paying for the car insurance is usually what I hear. So you're a step ahead. What you want to make sure is that as your child is approaching the 18th birthday, whether or not they're going to college, they're enlisting in the military, they're going to a vocational program, you want to sit down and talk to them about the fact that you're not going to be able legally to make any more decisions for them. But you'd like to be able to help support their decision-making process, especially if, let's say, they were in an accident. And the age from 18 to 25 has the highest statistic of vehicular accidents. So we know that happens. We also know that sometimes when our kids go to college, they get a little bit out of hand with the partying. And we've also seen situations of kids getting alcohol poisoning. So before we send them off, we want to think about things like a designation of healthcare surrogate, where the parents can get information from the healthcare providers. God forbid they're in the hospital, let's say. Or your child might have worked the summer before going to college, saved a lot of money, maybe they opened an IRA. Without a power of attorney, you're not going to be able to handle financial matters for them. So to me, this is just as important as planning that last family vacation before they leave, or planning the graduation party. Now, Ellen's question was focused more on what if you're working with a client, and as you get to know them, they tell you that they have a child with disabilities or special needs, and that child is approaching 18. Well, it's really going to depend on what the disability is and how the child is responding, you know, their level of education, have they had any vocational training? Everybody is affected differently. So we give everybody the benefit of the doubt. Maybe the person, if they're high functioning, might be able to sign a designation of healthcare surrogate. And it's not about can they hold the pen in their hand, it's about do they understand what they're doing by giving mom and dad or their sister or brother the ability to make decisions for them. If they can't, if they don't have that level of comprehension, Florida is very unique. We have something different than just guardianship here. We have what's called guardian advocate. And this is a separate law that is specifically meant for individuals born with a developmental disability. That means autism, Down syndrome, spina bifida, cerebral palsy, and there are several others. So with a guardian advocate proceeding, we are not taking people's legal rights away. They still have all the rights you and I have, meaning they can vote when there's an election, they can decide where to live, they can decide who to socialize with, they can even decide to marry somebody. But the parent or the sibling, as the guardian advocate, can legally be there guiding them along the way, helping them with the medical decisions, with the financial decisions. But they're still as involved as we can encourage them to be in learning how to make decisions for themselves. So a lot of parents prefer the guardian advocate proceeding rather than the guardianship, where all the rights could be taken away.
Perfect. Thank you so much. And how can we as realtors provide value to you and to your clients? What is it that we can do to really assist, whether it's senior relocation or a guardianship, situation, anything?
That's a great question. You know, I know a lot of you, Jose, you talked about being in your profession for 20 years. We've seen a lot of changes. I think we've seen life in the United States go from families living in the same city or state to all of a sudden people being spread all over. Sometimes children go work internationally. And so we don't always have the network or the support system that people need as they age. And so I think when it comes to those of you that provide relocation services, I think, Paula, you were one of the people who shared that you do that. It's important to be familiar with what else is in the adult child's area, because sometimes it may not be the best for both to have mom and dad come live in the same home with the adult child. And the parent, it may be too much to be a homeowner again. So you might benefit from becoming familiar with other professionals that can tell you, oh, we have this community here, and this provides 3 levels of care so that the adult can age in place. I think it would also be helpful for all of you to either become familiar wherever you practice with your local bar association. Every county in every state will have one. And at least here in Florida, I know that our county bar associations do have an elder law section. And so I think from a networking point of view, that's a great way to start working with attorneys like myself who deal with these issues, where you can collaborate so that when you have a guardianship issue arise, you have a probate issue arise with the homeowner, you have a team of professionals to support you and support the client. The other resource is a national resource, and that is the National Academy of Elder Law Attorneys. Their website is naela.org. And it's a great resource. You can go on the website and say, find an attorney, and then do your search by state, and then you can break it down even further for your geographic area. You'll then find people who specifically work in the elder law area, and it will tell you who is board certified. And so those may be 2 great resources for all of you.
You can repeat that URL, Stephanie, or the name, we'll put it in the chat for the.
Okay, so it's the National Academy of Elder Law Attorneys, and their acronym is naela.org.
Thank you. And at this time, I would like to open it up to have people ask any questions by raise of hands, any questions that you have for Stephanie. Sarah? You're on mute?
Unmute yourself.
Sorry, I don't usually do that. Are there similar protections, resources, rules available around family members with mental health issues?
That's a great question. So with mental health, we've got a whole nother law. So here in Florida, if you have somebody, first of all, with addiction, and sometimes addiction will be coupled with a mental health issue. People have a dual diagnosis. There is what is called the Marchman Act in Florida, which is mostly focused on helping individuals who have addiction problems, who need to get help. With mental health solely, we would be looking at the guardianship system. And there have been times where I've worked with people with mental health diagnoses, and once we can get them the consistent, stable treatment they need, it may be that down the road they can have certain rights restored to them once they show that they're able to properly handle those and make good judgment, good decisions.
So I'm dealing with this with a client right now. So if it's addiction and mental health combined, it's the Marchman Act. But if it is only a mental health related issue, it's through the guardian system, similar to
Correct.
If they had Down syndrome or.
So if they have Down syndrome, we're going to use guardian advocate more likely, because that's meant for people with developmental disabilities. If somebody has, let's say, a bipolar or a schizophrenia diagnosis, we would use the guardianship route.
Okay, thank you.
You're welcome.
And Sarah, I see that you're located in Florida, in the Tampa Bay area. I would encourage you perhaps to schedule a one-on-one with Stephanie afterward, although she's located in South Florida. I believe she practices throughout the state and could certainly introduce
Yeah,
you
I'd be
to some
happy.
good
There may be
resources.
resources that I can offer to you where you are.
Okay, thank you very much. I will reach out to you.
Hi, Stephanie. Russ Goodman up here in Jacksonville.
Hi, Rust.
Hey, thanks for doing this. I had a question. If you know you're dealing with a transaction, I just had one of this and my buyer did not get the home, but it was a home we had made an offer on. It was, I believe it was the guardianship where a younger party who was disabled actually owned his home and it was being taken care of by another family member. Are there any documents or certain items that we should look out for if we are on the buyer side to just make sure that we know the deal is going to make it to closing, all things being equal? Is there something that typically is brought to light that all parties have to sign in a case like that? Or is there a specific question that it's not out of bounds for us to discuss with the closing attorney, just so we know before we get too far down that path that they've got all the seller's ducks in a row?
Can you share with us what led to this transaction not being completed?
Oh, no, we didn't get under contract. It was a multiple offer situation, and they took a cash purchaser.
Got it.
This is my customer who was partially financed. So, but I was wondering, because I noticed when we made the offer, there wasn't a separate disclosure. It just said that there was something about the seller was not, was not the owner. The seller, the sign, it was almost like a relocation transaction where there was a different party signing than actually showed up on the tax records of the home.
Okay, well, you could certainly ask for the document that would show what legal authority that person has to be acting on behalf of the seller.
So we're not out of bounds to do that in a case like this.
I don't see that you are. And
Okay.
Whether it's going to be a guardianship court order or perhaps a probate court order, you could then show that to your client's attorney, and they may very well be able to look at the court records just to get more background.
Okay. All right. Thank you.
Very good. Great. Thank you so much, Stephanie. I really appreciate everything. And if you could put your information in the chat, I'm sure that many of the people on today's call would like to follow up with you after this as well. And at this time, I'm going to hand it back over to Jeff.
All right, everybody. Great content, great questions. Now we're going to go into our first of two breakout rooms. And if everybody can discuss two things, is either what you learned about this elder law realm and guardianship and okay, I'm stopping. What you learned. And then also, I have found that this time of year, there are lots of families having deep conversations. So what are you going to do from now to the rest of the year to help the people in your area and in your database related to either probate, estate, or elder law? So what did you learn, and what are you going to do from now to the end of the year? So I'm going to put in breakout rooms now and doing 4 breakout rooms. Assign automatically and go.